Hello, everyone.
Hey,
Hello.
And Miss Wolford, I got your email. I'll respond. Just give me some. I got it over the weekend, so I'll get back at you.
okay, thank you.
All right, I'll go ahead and start calling names. Lanaya Bates, Adiva Brown, Tiki Brown, Trenton Brown.
Here.
All right. I was about to say I ain't had none of my Browns here. The Browns ain't even here today. Got Trenton though. Jalen Chambers, Kelandria Dodd,
Yes, sir, I'm here.
Jay Downs. Jay Downs. Oh, she's checking in now. All right, Jasmine Dudley. Todd Ford.
Yep.
Taya Harris. Sydney Hatmaker.
Here.
China Hazel. Justice Hope. I think I see you, Juju, down there.
Yeah, I'm here.
Caressa Johnson. Vaughn Johnson. All right, Jalen Long. Shia McFadden. Thought I saw you sign
Here.
in. Brandon Merritt.
Here.
Got you. Lastacia Miller. Elliot Moore.
Here.
Taylor Moore. I see you up there.
I'm here.
Aaron Orr.
I'm here.
Cole Parks.
Here.
All right. Bria Pearson.
I'm here.
Gloria Peraza. Sorry.
Here.
Tatiana Philomar.
Here.
Genevieve Yomafio.
Here.
Mackenzie Richards.
Here.
Parrish Rippey. Naisha Ruff.
Here.
Serenity Sanders. Serenity Sanders. All right, Jasmine Smith. Jalen Thompson. Stacia Tyson. Jeremy Vick. Let me see where I'm at. Clarence Washington. Erica Watlington. I got to see you up there. Jaden Williams. I got you, Jalen.
Adiva Brown is here, by the way.
All right. Sorry, you check in. Who else? No, Jaden Williams. No. Latia Williams.
Here.
And Zaria Woodford. I know I said something to her earlier. She's here.
I'm here.
All right. Anyone else that did not check in? Okay. So everyone got or has viewed or had the opportunity to view Chapter 7's lecture.
Yes.
Okay. All right. Just very briefly, we'll talk a little bit about Chapter 7. Also, I have some announcements. Wednesday evening at 6. I know some of you guys might have me for Wednesday evening Zoom. We actually have our criminal justice full body meeting. So what I'm going to do, I'm going to instead of having our Zoom that night, I'm going to send the Zoom link so that you'll be there instead. It starts at 6. Also, for those of you that are not in that class, I will offer extra credit for those that do show for the Zoom. So I just got to figure out how I'm gonna keep track of it. I'll figure it out. I guess I can kind of see. I guess look at the side to see who all's here. So the rest of you guys, well, I guess you don't see a list of participants. You just see all the blocks, right? What do y'all see?
We can see the participants. It's 25 people on the call with their
so
names.
Y'all can see the list to the side. Okay.
What are we supposed to be deciding? I'm sorry, I missed it.
Y'all see the list on the side to the right? Because I have the blocks and I have a list to the side, so y'all can see that.
Yes, we can see it.
Okay, cool. I can kind of keep track. And then another thing you guys can do, you guys can also send me direct messages when you log in as well. So I think that'll be a better way to do it. Everyone just send a direct message when you log in directly to me, and I'll mark you as being present. I'll give you credit. So it'll be 5 points extra credit. So just log into the criminal justice, the full body meeting, which will be this Wednesday. So I'm waiting on them to get me the Zoom information now. Once I get that, I will send it out to you guys. I'll put it on my blackboards. So yeah, Wednesday night at 6. So my 6 o'clock. Those of you that are in my 6 o'clock Wednesday evening, we're gonna, instead of having class, we're gonna be on the Zoom, on the meeting for the full body meeting for the criminal justice department. Okay. So that's that announcement, and I had a couple people that just checked in. I got Stacia. Who else checked in? Somebody else checked in with you around the same time.
Bates.
Bates, okay. I got you.
Attorney Boyce, did you say Tyson?
Yeah, I got you, Stacia.
Okay, thank you.
Right.
Can you check your email after this? Because I emailed you like a day or two ago and you haven't emailed me back.
Okay. Normally when I get stuff on the weekends, give me a little bit of time when you hit me on the weekend. But I got you.
Okay, thank you.
All right. So where we at? So chapter 7, we talked about attempt, conspiracy, and solicitation. Those are what we call our inchoate crimes, or what we call incomplete crimes. Essentially what that means, those are the crimes that are kind of the beginning stages of other crimes. So of course, for it to be an attempt, that means you essentially try to commit a crime and didn't complete it for whatever reason. So that's what attempt is. Of course, the book delves a little bit deeper into exactly what it is. Then you have conspiracy, which is an agreement to commit a crime. Of course, it's an agreement between two or more parties, two or more people to commit a crime, and then some step has to be taken in furtherance of the crime. So it's not just an agreement. We can all agree on this Zoom right now to go rob a bank, but until one of us does something to push us closer to committing a crime, it's not really a conspiracy. It's kind of the same thing with same thing with solicitation. So, well, not the same thing with solicitation. So, solicitation is essentially either paying someone or trying to coerce someone to commit a crime. So we normally see that, and I know you guys can remember from my lecture, you normally see that in situations where I always call it the wife trying to kill the husband for the insurance money, and she gets the new boyfriend. She goes to the new boyfriend and says, "Hey, I want to be with you, boo. So I need you to kill my husband, though. And once they kind of, you kill my husband, I give you 10,000 or whatever. That becomes a solicitation, and at that point, the crime is complete as soon as the solicitation is made. It doesn't have to be any step in furtherance of the crime. So of course we have the mens rea of attempt is essentially some purposeful step towards the commission of a crime, and the actus reus is essentially an actual step taken, and that step you must have failed. Sorry. All right, you failed in the commission of a crime, or you decided not to do it. So, of course, I got you, Tiki.
Okay, thank you.
So it can kind of be used as a defense, or at least a mitigator, if someone attempts or starts to commit the crime and then decide on their own volition that they want to change their mind and not do it. So that can be a defense, or at least a mitigator. Then you have what we call impossibility. So you attempt to commit a crime that is essentially impossible to do. Something, and so it depends on the type of impossibility. You have one type of impossibility where essentially no matter what you do, it would have been impossible for you to complete the crime. Then there's a situation where you did everything you were supposed to do, but the gun, let's say you were going to kill somebody, but for some reason the gun jammed and you couldn't fire the gun. That is still enough for an attempt, because but for the gun jamming, you would have completed it. So that's attempt. Conspiracy is, of course, an agreement between two or more people. That's the one crime that requires more than one person. So of course, and you know, we talked about different conspiracy rules as well. But there's one rule I want to say it's the Pinkerton rule. The Pinkerton rule, and I want to make sure. Yeah, I think it is the Pinkerton rule. But with the Pinkerton rule, you can't. So if the crime itself requires two or more people, like something like solicit, well, let's say prostitution. Of course, we know it takes two to tango in prostitution, right? In that situation, they can't be charged with conspiracy to commit prostitution and prostitution. They would only be charged with prostitution. So if it's a crime, the in and of itself requires two people, then the defendants can't be charged with the crime and the conspiracy itself. But in other types of charges, they can be charged with the crime and a conspiracy in and of itself. So if we wanted to rob a bank, and you know we were on this group chat, and we plan to rob a bank, and I sent Bria Pearson to go get the guns so we can be strapped, and I got Cole on lookout, and we decided to rob a bank, and we actually complete the bank robbery, get out with the money. And we end up getting caught. Not only will we be charged with robbing the bank, but we'll also be charged with conspiracy to rob the bank. So conspiracy is charged as a separate crime from the crime itself. Now it is a lower crime. It's usually a couple steps below on the hierarchy, depending on what state depending on what they call it. But the classification of crimes is usually a rung or two below the actual crime, principal crime itself. But you can be charged with the crime and conspiracy to commit the crime. Now, like I said, unless the crime already calls for more than two people to commit it anyway. So that's conspiracy. Talked about the types of conspiracy. With the chain conspiracy, that essentially means just like a chain, every link is important. So the chain is not together if one of the links isn't there. So you have something at the beginning and there's something that carries out to the end. And of course, the best example of that is the drug trade or drug sales. So you have a supplier, or, you have a grower or a supplier, depending on what the drug is. If it's heroin, for instance, of course, that's grown in the field, and that actually cocaine is as well. But of course, it's processed somewhere, grown. Then once it's grown, it's processed. Then from there, there's usually a middleman or some type of distributor that gets it out. Then it gets out and it ends up getting processed again. Of course, where it's broken down into sellable form, and then it's put on the street. So you got everyone from the guy growing the pot, that has the poppy field in Asia, all the way to the corner boy that's on the corner. So all those people are part of a chain. If any part of that chain is broken, then the process can't be completed. So if there's no more poppy field, or the person that has the poppy field is no longer available, then that means there's no more supply. That means nothing else gets to the street. You guys watch The Wire or watch any drug movie, they call it the re-up. Of course, when they run low, they don't got no more dope. So if they don't have a supplier, they're done. So that's how it works. So it's a chain conspiracy. Then you have like a pinwheel conspiracy. A lot of pinwheel conspiracies, if you could imagine a wheel or like a tire, a pinwheel, and it has the spokes that connect it to like the what they call it, not the harness. I can't remember what it's called, but I cannot remember what it's called. But it's connected to it, and of course the wheel turns on it. So the spokes are all. So you notice they don't touch each other, but they're all connected to the center. So that means if one spoke isn't there, the tire can still, the wheel can still spin. Now, of course, if enough of them aren't there, then it's going to become wobbly. But what that means is if one of the spokes is gone, the conspiracy can still kind of carry on, and that person can probably be replaced. So normally that occurs in like if there's some type of white collar crime, or let's say some type of I'm trying to think. Maybe because we don't talk about pinwheel conspiracies that much. Usually that would deal in white collar crime, when you have one person doing this, another person doing this, and it all feeds the middle. So there's usually one hub or one hub in the middle that kind of feeds off everything and makes the money or makes it work. So those are conspiracies and the types of conspiracies. Solicitation, as I said before, when the person tries to get another person to commit a crime. So of course, with solicitation, if you go up to someone and say, "Hey, I need you to kill my boyfriend for me. Here's $10,000." At that point, that is solicitation in and of itself. No steps have to be taken in the furtherance of the crime. So it's not like the conspiracy where steps have to be taken, or of course, and also with attempt, steps have to be taken as well. But with the solicitation, no steps have to be taken. So those are the three what we call inchoate crimes or incomplete crimes. So I just want to run over that. Any more questions, and then we'll move on if there's still any questions about the writing assignment, or is everyone done with that? If we cross that bridge, I guess we have crossed that bridge. Okay. So don't want to go very deeply into chapter 7 because I've already given you guys a whole lecture, which you guys have a link to. So are there any questions at this point? All right, perfect. So once again, I know I got some new people that signed on. There will be a full body criminal justice departmental meeting Wednesday evening at 6 p.m. I don't have the Zoom information yet, but I will be putting it up. If you attend, you get extra credit. So it'd be good to have you guys there. So it'd be worth 5 points, just your attendance. Just be there and do what y'all do here. Cut your screens off and just chill out and watch TV. I know that's what y'all doing. Or playing video games or something. It's cool. But just show up for the Zoom and direct message me once you get in the Zoom to let me know you're here, you're in, and I'll keep track of the names that log in. And I'll give it. So, and matter of fact, it's extra credit. Some of you guys have me for more than one class. So for every class you're in, you get 5 points extra credit. Okay. So I really need you guys to be on the Zoom. So there's going to be other extra credit opportunities throughout the month of October. Which you said which Zoom is it, Bria? This is the Wednesday night Zoom, so it's gonna be Wednesday night. So if you, I don't know if you have my Wednesday night class.
Professor Coleman sent out the link. I can forward it to you if you want
forward that to me because I didn't get it in my. Let me check. I didn't get it in my email. Cause I texted him about it last night, but I didn't. Okay, hold on. Okay, I see it now. Full body meeting. So it's like a Word document. I see it. Okay, cool. So what I'll do, I'll post the link to our Blackboard and the meeting ID and the link. So I'm guessing it doesn't have. It looks like it doesn't have a password. Okay, so I guess it must be somebody controlling who gets in or whatever. But it doesn't have a password. But it does have a link. So so we're gonna do that this Wednesday, and I think the Wednesday after that we're gonna have like a town hall meeting or something like that on police brutality. We're going to talk about the Breonna Taylor case. And actually, I'm going to be speaking a little bit on that as well. So we're going to talk a little bit about that. So and then there's
30 boys.
Say again.
I don't want to interrupt you, but so are y'all going to break down like the facts and everything in the case in that town hall meeting?
As much as we can. So
No.
that's the thing about the Breonna Taylor case. Like from where we are, of course, it's hard to get facts, right? Everything we are hearing is secondhand. Like I looked at a documentary, the documentary on Hulu, and that's like the best information I got. And the sources of that documentary seem to be like court documents, like the warrant itself and everything. So I have some opinions on that, on what happened. It's definitely unfortunate. But it's deeper than just those cops that shot her. So I'll delve deeper into it when we talk on the at that town hall meeting or that Zoom. But I think by focusing on the cops that were there and served the warrant, I think we're leaving out a whole bunch of institutional stuff within that city. There was a whole bunch of stuff that went on, because the cops that actually were there to serve the warrant weren't even the cops that took the warrants out. So that's what's crazy about it. So it was really bad policing. Guys that didn't know exactly what they were looking for, guys that had nothing to do with the actual investigation. They were just kind of called as a task force to come raid like 6 or 7 different houses. And it was really weird. Based upon the information they're saying they used to get probable cause, honestly, Breonna Taylor's residence wouldn't have been a high priority residence anyway. So there was no need for a no knock search warrant. They could have easily knocked on the door and just said, "Hey, we got a warrant. We're coming in." It didn't have to bust down the door. I think they saw like one transaction or something like that. But I don't want to get deep into the facts. Plus, I need to do a little bit more fact checking myself to make sure I can speak as intelligently about it, because I have some opinions about it. But I want to make sure I don't want to give opinions. Now we're all we're all here in North Carolina. No one is in Louisville. No one has access to court documents. So it's hard to really know for certain. So we're gonna, essentially everyone's having these town hall meetings, and it's all pretty much based on conjecture or what we heard from another source. But I'm going to speak as best I can and give my opinion from a lawyer standpoint, even about the indictment and the failure to get the indictment and what that process is. So just tune in for that. So I'll send that link out. I'll put it in Blackboard, and I guess I'll let you guys know later on in the following weeks when we're going to talk about the Breonna Taylor case in the town hall. So who's that? Somebody just signed in. I want to say it was somebody with last name. Who was it? Who just signed in? Oh, Jalen. Jalen, it wasn't the B last name. Jalen Thompson, I got you. I just marked you present. So yeah, but that's it for this evening. You guys don't have any questions. Chapter 7, like I said, it was one chapter. It was pretty smooth. Anything you don't understand, the questions, ask them now, stay on, or either email me. And I got Miss Woodford and Diva Brown. I will be returning your emails promptly. Okay. If there's anything you just want to, if you just want to stay on the line and wait till the end and talk to me about it, you can do that as well. Let me know what you want to do.
I'm gonna just stay on the line.
Okay. So Zari's gonna stay on the line. What about you, Miss Brown? Diva? Diva Brown. I guess okay. So yeah, just stay on the line. So if no one has any questions, you guys can go ahead and sign out.
Thank you.
All right, y'all be good.
You too. Thank you.
And I think I got everybody on the roll, so y'all are straight.
Thank you, attorney boys.
Yes, ma'am. Be good. All right. Miss Woodford, go ahead. There are a couple people still here. You fine with that?
Yeah, I don't mind. I was just wondering if, like, for maybe the next paper, for one, are we gonna get the like, did you submit notes and things about what we did wrong on our past assignment? Because I was
Yes, you should have gotten an email. Let me see. So if you turned it in as a Word document, I corrected right there in like the red and lined out stuff and wrote comments above where I graded, and I sent it back as a PDF. If you didn't have Word and you sent it as a PDF, I had to actually print it out and do it in handwriting, in my ugly handwriting, scan it, and then send it to you. So let me see. What's your last name? Miss Brown. Who? Miss Woodford. Yeah, so I know I graded yours, so you would have gotten an email. So it should have been so in the email that you used to send it to me, I responded with that. So I just replied with the graded and it should have the graded assignment attached. Matter of fact, let me see if I can pull it up.
Let me see if I can.
So and I know you got a lot of guys have concerns. So one thing about how this class is graded, it's all points. So let's say you got a 5 out of 10 or a 6 out of 10. Of course, you're like, oh, that's a 50 or that's a 60. That's an F. No, it is not. It is 5 points out of 10 towards the 100 points over the semester. So like I said, so let's say if you did make a 5 or a 6, guess what? I'm giving you guys 5 point extra credit just for showing up next week. And then there'll be other 5 point extra credits. As a matter of fact, I'll give an extra credit writing assignment towards the end of the semester as well. So you'll end up having 3 writing assignments: the 2 that are assigned, the writing assignment 1, writing assignment 2, and then I'll give a extra credit writing assignment as well. So you have opportunities to get the points. So don't look at it on a what would I say, on a assignment by assignment basis. Look at it as the points you're accruing through the whole semester. And then also remember your attendance at the Zoom sessions is important, because literally that's 10% of your grade. So that's another 10 points right there. So if you think about it, that means pretty much each Zoom counts as a matter of fact, so you have 12 Zooms, so you think of each Zoom counts as like one point towards your grade. So if you think about it, every time you're not here, not present at the Zoom, those are points you're losing. So yeah, just think of it that way, and then just mathematically, honestly, even though we have 12 Zooms, but I'll probably count 10 of them to make it easy math. So you essentially have 12 opportunities to show up 10 times. So essentially, I'm pretty much giving I'm spotting you guys two Zoom sessions anyway. So it kind of allows you to get that 10 points. That's a freebie. Just be here, and that's 10 points. So I know a lot of people are concerned because the writing grades come back, but I have to keep it real with writing. Because I do have some people that have law school interest. Now, do you have an interest in law school, Ms. Woodford?
Yes, I do.
Okay, so that's good job.
I've been.
Who else does? I know Todd Ford does. I don't know about Trenton. What about are y'all Todd? Are you even still on the call, or you just haven't hung up?
Yeah, I'm here.
Okay, Trenton, are you there? Trenton Brown. And I know Adiva's there, right? Adiva? Okay, but it's good that if you really care about your writing, you're doing the right thing by asking questions, because this is like, not many undergrad situations where you're going to get an opportunity to write, like to be asked to write like a law student, and then have it graded by someone that went to law school, so that once you get there, you kind of have a heads up on other people. Because the one thing about law school, writing is super important. There are 2 things you're gonna do. It's like 50-50, reading and writing. Not even just reading critically and writing. So if you can't do one of those, literally you pretty much aren't gonna do well in law school. Now so you can't get 50%. You can't be 50% good at something in law school, at something like law school, and make it. So you got to be a good writer, and you got to be a good critical reader. So you have to have both of those. So it's good that you guys, if you do have concerns about your grades, that you're asking about it now, because that's what you want to do. So I want to kind of prepare my students to be the best writers they can be. So the thing about it, depending on I would have to look at the sheet where I graded yours. But a lot of people didn't. Some people didn't write badly. Now, some people, it was just bad writing. They were lazy. But there were some people that didn't necessarily write badly. They just got the wrong answer. So I will honestly say I won't say it was a trick question, but it was kind of a trick question. The reason I say it wasn't a trick question is, like, when we went over when we went over chapter 2 on the Zoom, I know I definitely kind of stayed on some of those points because I knew you guys were going to get a paper on these exact points. That's why I talked about the equal protection analysis, how to do it, how to go step by step in doing it. So there was a reason I focused on that on our Zoom. So and when I actually did the chapter lecture, I went through it, but I kind of had to go through everything else in the chapter as well. But if you remember on the Zoom call, I pretty much just stuck. I mean, I talked about a little bit of the other stuff in that chapter, but I focused primarily on the equal protection analysis. Now, the reason I wanted to do that is because I knew that you guys had that essay coming up, so I literally did it. So I was kind of almost. I was like, I didn't want to give you the answer, but I wanted to tell you how to get the answer. So I was hoping that me giving that lecture, me giving that Zoom lecture would kind of push you guys in, and give you guys the momentum you needed to do well on the essay. So it was only a trick question because I changed some facts to see if you guys were paying attention in your reading. So not getting there were really maybe only a couple. Yeah, I had no perfect 10s. I might have had one. I had 2 9s out of like 40 students. So there were only 2 people that even earned 9s. I think I had a couple 8s. Let me see. 1, 2, 3, and 3 8s. So everything else was pretty much 7 and below. And then there was some people, some people didn't even turn it in. I don't know why, but it is what it is. So honestly, if you got above a 5, you actually compared to your other classmates did all right. And then you got to think. So I'm grading based upon, of course, you get 2 points for turning it in. So pretty much it's an 8-point assignment as long as you turned it in and it met the criteria, the 2 pages and stuff like that. You will get 2 points just for doing that. So you got that 2 points, and the second 2 points was getting the overall right answer. So as I said before, you could tell I didn't really care as much about you getting the right answer because it was only 20% of the grade. So you got to give me 20% just for turning it in. Then there was another 20% for getting the right answer. So of course the right answer in this situation would have been to grant the motion to what's that? Yeah, to not grant. I'm getting classes mixed up. Would have been to overturn the conviction. So the Supreme Court would have overturned the conviction. So if you said overturn the conviction, you got 4 points right there. After that, that's when I really wanted to focus on the quality of your writing and also whether or not you were even in the ballpark with the rule. Because the one thing about answering legal questions is, so for one, there were only, now you got to think, and the way, that's another thing about the way I structured the question. I also kind of told you where to go, and you only had 2 answer choices. It was essentially either you grant or you deny. So even if you rolling the dice on the answer, you could have rolled the dice. You got a 50-50 chance. You got a 50% chance of getting it right just by saying, if you said I'm going to, I keep mixing the classes up. If you said we're going to overturn and you got lucky, you got 40 points for turning it in and you got lucky. So that last 6 points was about the quality of your writing and whether or not you actually applied the right rule. Were you in the ballpark or did you just guess? So it's all about, it's about your writing and the application of the correct rule and the full statement of the rule. Some people might have said, yeah, equal protection of the Fifth Amendment stated it, but they didn't really do a full equal protection analysis. They didn't tell me, what level of scrutiny applies and why. They didn't explain to me how the equal protection, how it goes, how the analysis goes, how you ask yourself, first, does this law discriminate? If it does discriminate, on what basis does it discriminate? If it discriminates on the basis of race, then we apply this standard of scrutiny. And that, so you would have to go into all why, but it's essentially the Supreme Court said that racial discrimination, any law that discriminates based upon race, is what we call a suspect classification. If it classifies people based upon race and nationality and religion, those are what we call the suspect classifications. So to treat someone differently for any one of those reasons is suspect on its face. So then so of course this law treated people differently because of their nationality. They were essentially, they were saying all, Asians, so of course it's differentiating people, classifying people based upon their country or, their country of origin. So that's nationality. So that means you're going to apply strict scrutiny. So then once you apply strict scrutiny, a lot of people said strict scrutiny, but they didn't necessarily explain what it meant, So it means that, of course, the law on its face is automatically deemed to be unconstitutional, and it must be proven constitutional by the government or the maker of the law. And in order to prove that it's constitutional, they must show that it's narrowly tailored and the least restrictive means of satisfying a compelling government interest. So there's two things. So let's say two things: the narrowly tailored and the least restrictive means, and then it also had to be for a compelling government interest. So then you had to apply that test. So looking at it, okay, was it narrowly tailored, meaning well written, and the least restrictive means? But then when you look at it, that's why I put certain facts in there to test your reading. I open up by saying we were attacked by Japan. Then I told you that Mr. Yu was Korean, so he wasn't even Japanese. And then I said the law said all Asians. So in other words, if they create that law to protect this house law that says all Asians must move, that is a large group of people. So it's not narrowly tailored, and it's definitely not the least restrictive means. Essentially, they're trying to, anyone that's from the whole continent of Asia that's in America, or originates from that country, in any country in Asia, must now move away and can't live near a classified area. So that in and of itself was crazy. So it'd be one thing if it said Japanese, and that's another reason why I brought up. We talked about the Korematsu case. I made sure I talked about that on the Zoom as well, because I was pushing you guys into kind of pushing you guys where I wanted you to go to get the answer. So it was a test about how critically you read, how you noticed certain facts. Yeah, was just joining. But whether or not you picked up certain facts and used them, and then after that, did you apply the correct rule, right? So that's why I put certain stuff in there. I wrote it a certain way. What else? So I wanted to kind of lead you into what you needed to use to get the answer. Something else I was gonna say. Yeah, I spoke about Korematsu because I wanted to lead you. I wanted to kind of get you guys thinking about it. So I was like, now I was also testing. That's what I wanted to say. I was also testing whether or not you guys were listening to me. So that's why I was like, if I'm essentially gonna have a whole lecture on Zoom where I talk about what they're gonna need to answer this question, and then I give them the question, that's gonna let me know. Justin, if they applied the rule, if they got it right and at least halfway applied the rule, even if they didn't state it well, if they at least got it halfway right, at least stating the rule, that means at least they were listening to something I was saying. So it just depends on what your grade is. Whether you got the 2, 2, 3, 3, or whatever you were checked off for. It might have just been writing quality or your organization. And that's also the reason I talked about the IRAC and CRAC format and how to write. That's literally what I'm expecting. I taught that because that's what I want you guys to write. So of course I kind of start off. Go ahead, Ms. Woodford. I'm sorry. I'm talking.
I just wanted to make sure that you said that the event on Wednesday, that's not this Wednesday the 30th. That's next Wednesday the 7th, or is it the 30th?
I got the 30th. Hold on, because we just had our departmental faculty meeting Friday. Yeah, September 30th is this Wednesday. So yeah, I'll matter of fact, let me go ahead and screenshot the flyer. Yeah, so I'll post the flyer, but what I just talked about, does that answer your question? Is that what I'm assuming you want to talk about the paper?
Yes, I'm okay. I'm all right now.
All right. So I promise you. So it kind of flip flop with classes. My 313 class, they started out, their first paper was easy, and their second paper, I don't know if you're in that class, is going to be a little bit more trickier. You guys had the trickier paper, and then your next paper, the second assignment is going to be, it's not going to, I don't really think it was that tricky, but it's not going to have it's not going to have as many stumbling blocks as this one had. So you'll be fine, but just focus on your writing structure, IRAC and CRAC writing. That's pretty much what I'm looking for. Some people are in their writing, literally, you got to think as a grader of a write. So not even just as a grader, as a reader of your writing. So the reason I teach IRAC and CRAC is that's kind of the language of the court. So anything I write for the court, now I don't do a lot of brief writing anymore in my practice. But when we write briefs and we write things to the court where we're trying to persuade the court to see it our way, we write in an IRAC format. That means when the judge looks at or the decision maker or the judge looks at it, they're looking at it, and the first thing they need to know what the issue is or what our contention is. So, of course, in the actual practice of law, I'm not going to write a lot of issue stuff. I'm already on a side, right? So I represent either a defendant or a plaintiff or a defendant or if I'm the prosecution, I'm the prosecutor. So if I'm writing a brief to the court, I already have my contention because I'm on one side or the other, right? So I literally open up with my contention. I want the court to know within the first 2 or 3 sentences what my contention is. Your Honor, you should dismiss this case, or or this person is not guilty. The rule I'm applying is this, North Carolina statute this, and it means this, and I believe it means this or whatever. And then I start analyzing by taking facts from my case and applying it and showing how the facts fit in or don't fit in. If I'm trying to say they don't fit, and then after that, then I close by saying, therefore, or in closing, because of this, and this, my client is not guilty. So if I'm or the case should be dismissed, or the evidence should be thrown out or suppressed. So IRAC and CRAC, that is the language of the court. That's how we talk to the court. And like I said, it is a form of what we call persuasive essay writing. So it is like the distant cousin. I want to say this, yeah, I would say the cousin, the first cousin of 5-paragraph theme writing. The reason I taught you guys that first is that's like the basic essay writing format, 5-paragraph theme. Your contention, a number of reasons why, and then you close. So that's how that goes. And so it's not too much different, but it's different because, you're either doing a contention or issue, then you're telling me the rule or the rationale you're going to apply to answer the issue or to tell us why you contend the way you contend, then tell us what facts apply and how they apply, and then close. So a lot of people, some people in their writing, what I saw some of is some people, what happens is I tell you, this is probably the shortest paper you got for every class, right? It's not even really a paper. It's not a research paper. It's an essay. So you're just asked to do 2 pages, 12-point font, double space. So in doing that, that's a relatively short paper. A lot of people are still want to answer the question, because they kind of get lazy. They want to be able to give me they want to be able to get the length of the paper because I don't know how to answer it to give them the full answer. But if you answer it like that, if you give me an issue statement or a contention statement, and a rule, you state the rule, because you think about the equal protection analysis, just talking about that, talking about the Fifth Amendment, how it applies, and then, the steps of the equal protection analysis. If you're telling me that, that's 7 or 8 sentences right there. And then you have to, once you get to the analysis portion, then you're having to go through those steps. And ask the first question, or does is this a law that differentiates and classifies? Yes, it is. It classifies based upon nationality. Because it classifies based on nationality, we would apply the strict scrutiny test. The strict scrutiny test, as it said before, says it must be the narrowly tailored and the least restrictive means of meeting a compelling government interest. Now, in this case, it wouldn't be narrowly tailored because the nation was at war with Japan, and it's actually so unnarrowly tailored. The person that got arrested for violating the law wasn't even from Japan; he was from Korea. Because the law says all Asians, and that's kind of you explain why that's not narrowly tailored, and the least restrictive means. Then you go on to compelling government interest. Is there a compelling government interest in protecting ourselves? Yes, there. According to the Korematsu case, there was a compelling government interest, but here there's a compelling government interest, but there's not a least restrictive means or a narrowly tailored means of carrying out that purpose. Therefore, the law will be unconstitutional. So I just said all that, right? And it took me a minute to say it. Imagine if you were writing all that. It'd be easy to get 2 pages. But what people are doing, because they don't want to go through all that, they're opening up their paper by giving me the facts I gave them. Like literally, now of course you get my paper in a PDF format, so you can't copy and paste. But if they could, I think they would go through and literally copy and paste and just put it and begin their paper. So you're beginning your paper by telling me the facts that I gave you. Some people are not saying any one of you did it, because I can't remember, but people were doing that. So they do that, and I know that is a means of the reason people do that is they know if they can give me back everything I gave them right up front, that's a page, right? And then the rest of it is lazy stuff after that. And now I got a 2-page paper. Yay, I turned it in. So that's what they're doing. And in my reading, it immediately makes me mad. I know this person about to get a terrible grade literally within the first 10 seconds of reading that paper when I see that, because I had to read a whole page to figure out what their answer is. What is the issue or what the answer is. I need to know within the first 2 sentences either what the issue is going to be, the issue is whether, or I need to know what your contention is. I need to know that right off the bat. So either the first sentence, and even if you want to, and I would say to be safe, open up with that as your sentence. But some people, might have a sentence or 2, and then they'll get to it. I prefer you get to it as soon as possible. So if you want to waste a sentence, I'll say waste a sentence at most, and then get to the point. Tell me what your contention is. Tell me what your issue is. So I know that. So I know, okay, this is where they're going, or this is what the issue is. And if you state the right issue, I know you might be in the ballpark. So it helps me follow your reading. Then the next paragraph break. Now you're going to tell me what the rule is. So then I'm like, okay, so if this is what their contention is, or what their issue is, what rule are they going to apply, or what rationale are they going to apply to come to a conclusion? So then I look at that. So that lets, as the reader, I'm like, okay, they're gonna apply the strict scrutiny analysis. So it's not just telling me what you're gonna apply. Tell me what it is and how it works. How the Fifth Amendment equal protection analysis, and the equal protection analysis of the Fifth Amendment. We look at laws that differentiate or classify. If they classify, we apply the equal protection analysis, and you tell me all that about strict scrutiny. You can even waste 2 or 3 sentences telling me about what the other 2, the rational basis and the intermediate scrutiny, apply to. Now, don't spend a lot of time on that because it's pointless, because that's not really what this paper is about. But you can tell me that. I won't count off. But as long as you're applying the actual rule, and you're explaining it fully, and you tell me, now I know what rule you're applying. And then from there, I transition down to your analysis. And that's where I get to see, well, is this person going to pull specific facts from the reading to help make their point. So tell me what point you're trying to make. Of course, we have the rationale you're applying, but apply these facts to the strict scrutiny. Apply the strict scrutiny test to these facts and tell me why or why not. And then at the end, say in conclusion, and the conclusion paragraph is pretty much almost a repeat of the very first paragraph where you opened up with contention. Now, if it's an issue statement, of course, the issue, you're telling me what the issue is. You're not telling me what the answer is up front. But you do need to come up with the answer at the bottom. Some people are like, well, either or. It's like, no, you gotta come up with an answer. So when you go to that now, if you're going to write an issue statement at the end, you're going to have to end with either yes or no. And these, the answer in this situation would have been either you're going to overturn or you're going to confirm his conviction or affirm his conviction. So you need to tell me either one of those at the end, and then give me a brief 2 or 3 sentences as to why, just to recap, and that's it. So if you did that in your writing, that's 2 pages. But some people literally kind of might not have listened at all to my lectures and what I talked about, or they were just like, hey, if I do it his way, I don't know how I'm gonna do it. I don't feel like doing it that way, so I'm gonna just give him what he gave me, and that's a page. So it lets me know right off the bat that you're not even trying. So like I said, there was very few people. There were a number of people that wrote that did it that way. But for most people, it's just kind of my things they did that I checked off here or there. They didn't apply the right rule. Or a lot of times, people wouldn't give me a full rule statement. They wouldn't talk about where it applies and what the equal protection analysis is and the strict scrutiny test of the equal protection analysis. So because there were incomplete rule statements, that means I couldn't, I had to take off points because you didn't tell me anything. You have to assume you're writing for me as if I know what's going on, but I don't know what the rule is. So you have to tell me this stuff like I don't know. Now you don't have to teach me the whole semester in that, but explain what you're talking about as if I don't know. So imagine if the grader does. So I'm trying to look and see. So in order for me to know what you know, you have to tell me what you know. So you have to assume I don't know what you're talking about. So explain it. So any more questions? Diva, did that help you out? I'm assuming you want to talk to me about the paper.
I don't have any more questions.
Okay. Diva down there, you fine? Okay, she's on here, but she's not saying that. All right. Todd, you good? Trent, you good? Jasmine Dudley, I just marked you as being present, so you're good.
Yeah, I kind of got a question.
Go ahead.
But like, it's just kind of like unconsequential. Like it's not really, I don't know. Like it's really just to kind of like get like feedback from you. Like it's not really about like I only care about the grade for the paper. Like it's just kind of like,
Okay.
All right. So what like the bringing up the Korematsu, right? Like in your analysis and of the precedent, like I understand like the discriminatory act, like the basis of it not being like of it being wide and not like narrowly tailored to just Japanese and instead of like Korean. But like, so where I was going with my analysis, right? Like, so at the same time of the Korematsu case, there was the other case, the Endo case, right? And they freed him because they said no citizen who is conceitedly loyal presents a problem of espionage or sabotage, and they have to be freed. And like his case, they freed him as soon as they freed him and.
But the Endo case, if you use the Endo case, what you did was you assumed certain things I didn't give you in the facts. I didn't tell you that Mr. Yu was not was loyal. I just told you he was playing cards and where he lived at, right? So by mentioning the Endo case, you brought in you kind of created facts I didn't give you, and it led you to bring in a case that wasn't really relevant. So the only case that was really relevant or really kind of matched, or you could talk about if you want to talk about the case at all, because you notice I haven't mentioned that you had to mention the Korematsu case. If you mentioned the Korematsu case, that was good, but you didn't have to go, tit for tat and pair it up. But you could have analogized and distinguished the cases. So remember that I didn't mention anything about him not being being loyal or like you said in the Endo case, if he wasn't a spy or something like that.
Yeah, like I did it like based off the because like I feel like you'd have to have evidence that you weren't loyal if you were, because you said he was U.S. born, right? Like he was just of Korean heritage, but he was U.S. born, so he's like
I don't know
he was a U.S.
I
citizen.
didn't even make any mention of where he was born. I think I just said he was I might have said he was Korean descent. So what you're talking about, another thing you have to do in your writing, and so writing is also reading. So that means you have to read the prompt correctly to understand and to make sure you write well. so only use the facts that I give you in the four corners of the paper, right? Of the page of the fact hypothetical. So a lot of stuff you're talking about is assuming things that aren't in the facts. So
Gotcha.
so always stick to what I gave you, because like, so in applying that case, that means you were assuming certain things that aren't said at all in the essay prompt. So always be careful not to do that. So when I'm giving you an essay prompt, what's on the paper is what it is. And I make sure I write them carefully so you have everything you need to answer the question. So you would have wasted some space in your writing talking about something that was totally irrelevant. So in future reference, just make sure you try to stay away from assuming things that aren't directly stated in the paper. So if it's not said in the paper, you can't, what did I give you in the paper that would make you figure out whether or not he was a spy or a loyalist? I just said he was a dude, he was a guy of Korean descent that lived across the street from Fort Bragg. So that's it. But I didn't say anything about whether he. So there's no evidence, nothing in the facts that would lead that where you could draw a conclusion as to his level of loyalty. So for future reference, be careful not to do that.
I got you.
All right, everybody good?
No, that ain't even why I stayed on. I just kind of wanted to throw that out there since you was talking about it.
Good.
No, I had a question about so I gotta write like now I gotta write a response to like a fact hypothetical, right, for this application. Like I just wanted to kind of like bounce it off you. It's like it's not like a mock trial type writing where like you do it in court. Like it's asking about like the investigation process. Like I have to write about like that.
Mm-hmm.
So like it's weird.
So does it want you to apply a certain body of law? So is it a question where they're asking for a legal answer, a legal summation?
No, it's just it literally is asking me how I would build my defense for a person who's been accused of an armed robbery, and it gave me like kind of like people that said that there are his alibis, and it said like you get like the sheet of the person, the complainant, the person that filed it. Like you get like a sheet that has like their information on it.
So it gave you facts.
Mm-hmm.
Okay.
And it's asking me how I build my defense. Like how do you go about investigating to build my.
So in other words, if it's saying how you build your defense, that means that means it's telling you what side you're on. So that means you would open up with the contention. So, my client is not guilty because, he's not guilty. My client is not guilty of armed robbery because blah, 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 blah. A couple sentences, then move the law of armed robbery. Hopefully they gave you the definition of armed robbery is in whatever packet they gave you, right?
Yeah, I think so.
Yeah, so then you say armed robbery in this, it's probably going to be some fantasy jurisdiction, is defined as blah, 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 blah. And then you, like I said, you get to your analysis portion where you talk about those facts. And you talk about how, you're essentially talking about how there's going to be reasonable doubt because this fact isn't satisfied, this fact is, so we haven't got to the elemental crimes yet. So we haven't. So we just talked about the inchoate crimes tonight. So when we get to crimes and we talk about crimes against the person, murder, stuff like that, we're gonna have crimes that have what we call elements. So they're gonna have almost a checklist. The elements are like the checklist of things that need to be completed before this person can be guilty. So armed robbery would have a checklist of things. It's probably the taking, the physical taking of an object from a person by use of force or threat, or by the threat of force from a weapon. So you state those and you kind of break it down elementally. So You say, okay, it was there taking by force? Or was there taking? In taking something from someone, did this person use the threat of a weapon? And that's pretty much what armed robbery is. Taking something from someone by threatening use of force with a weapon. So you have to go to the facts to say whether or not those elements are met. So for you, you're going to be arguing why the elements aren't met. So in your fact analysis, you're gonna point out those things. So you want to talk about all the elements. This element is met because of this. And then you want to also in doing that talk about the elements that are not met. So if you break down a definition of the crime or the law itself in elements, then you go element by element, saying why, what in the facts, either why it meets it or why it doesn't meet it. And of course, as the attorney, you're trying to argue that all the elements. So if one out of 5 elements is met, that's cool. But there's still 4 other things that have to be proven before this person can be guilty beyond a reasonable doubt of this crime, of the crime they're accused of. So just because one element's met, and even if 4 out of 5 of the elements are met, there's one. Every element has to be proven beyond a reasonable doubt. So if there's one thing that's missing, that's all the argument you need to defend someone to say why they're not guilty of the crime. So you still do a C rack. It wouldn't be an I rack at all, because they've told you what side. So you do a C rack. Give a contention statement. State the rule that you're applying or the rationale. Of course, they gave you the armed robbery. So just state the definition based upon what they gave you. Then go element. Then in your analysis portion, tie the facts to the elements and say why this is met, why this isn't, why this is, and then in conclusion, my client is not guilty of armed robbery because there was no use of a weapon. He didn't threaten the use of a weapon, and he didn't have a weapon, or he didn't hold himself out as if he had a weapon. Because with armed robbery, you don't actually have to have a weapon, but the person you're robbing has to be in fear. In other words, you have to make them feel like you have a weapon. Like if I come up behind you and I got a banana in my pocket, I'm like, give me your money. It doesn't matter that the banana actually isn't a gun. It's the fact that you think that I essentially made you think that the banana was something that will hurt you, right?
Gotcha.
So that even with a banana in my pocket, that's still armed robbery. So that's what you want to use to. So it's all about the threat of force that was used. So if you see racket, you'll be good. Now, what is this for?
The public defender's office in DC.
Okay. For internship.
Yep.
Yeah, C-rack that thing, man. You C-rack that thing, they gonna be like, oh, this boy can write. Hey, we need him.
All right.
We like the way he thinks. So it's all about organizing. So that's why you want to break down the definitions in an element form. What this, and this. Like, so what is the definition of the armed robbery? They're gonna give you some type of statute or something like that. And then in your analysis portion, you go element by element. And that's literally what I do every day. If I'm defending someone, are all the elements met?
All right. Appreciate it.
All right, y'all be good, Miss Woodford.
All right.
Have a good one.
All right, take care.
Wait, and don't forget to send me the.
Yeah, so you gonna talk about mock trial at the so whenever they can. I've already given them your name and told them you're gonna be presenting for mock trial. So just, when it's time, and I may introduce you. So then you just talk about what we did. I'll talk about it a little bit as well, and you go from there. So I'll actually, instead of me just sending you the link is going to be in Blackboard. So just so it's not going to go to just you. It's going to go to everybody. But just know you're going to talk about mock trial.
All right.
All right. Be good.
All right, you too.
Take care.